Welcome to Just Verdicts with your host, Brendan Lupetin, a podcast dedicated to the pursuit of just verdicts for just cases. Join us for in-depth interviews and discussions of cutting-edge trial strategies that will give you the keys to conquering the courtroom. Produced and powered by LawPods.
All right, everybody. Welcome back to the Just Verdicts podcast. Me, Brendan Lupetin, and today I am joined by attorney Andrew DuPont, who is a partner at the Locks Law Firm, and we are going to talk a lot about and learn a lot about the dangers of benzene and the results that it can lead to in trial. And Andrew and a team of lawyers that he worked with got a spectacular verdict against Exxon. I read about it, and I said, I've got to talk to this guy. So, Andrew, thanks for joining me today.
Thank you for having me, Brendan. I appreciate it.
Yeah, and thanks, like so many others have had to do suffering through the tech setup ahead of time. We got the headphones going, we're good to go, and we both sound pretty good at this point. So, before we jump into this, tell us a little bit about yourself. What your practice consists of. I read, partner at Locks Law Firm. Seems like you guys do predominantly toxic torts, but I'm guessing you do other stuff like that. What is your specialty? It looks like you've been there since 2003. Kind of walk me up to how you got to, be trying cases like this one against Exxon.
Yeah, so born and raised in Philadelphia, joined the firm when it was Greitzer and Locks at the time. Second summer in law school as a paralegal, continued to work through my third year in law school as a paralegal. Right before I graduated, a partner and a couple other associates had left the firm, so there was an opening. Our firm has a long history dating back to the 1970s in handling toxic tort cases. Gene Locks was one of the first lawyers to be trying asbestos exposure cases against Johns Manville and other companies like that. And for decades, the firm continued to do that. Got into pharmaceutical litigation as well, some Agent Orange litigation. By the time I started with the firm, we were still heavily involved in asbestos and pharmaceutical litigation, but when I'm graduating law school and joining the firm as an attorney, we'd been involved in some environmental benzene exposure cases. Not occupational yet, but because of all the work that was put into those cases, we decided to get into occupational benzene exposure cases. I had the opportunity early on, because I speak Portuguese, to represent a lot of Brazilian immigrant workers and try some of those cases, try some asbestos cases, and then got more and more involved in the benzene exposure litigation. And that's been primarily what I've been working on for the last almost 20 years now.
Can you give us a little primer on, benzene? I've obviously hear about it in different forms and, the dangers it poses to people, carcinogenic and so forth. But can you summarize a little bit, like what was some of the background, studies that came out making the link that, then creates sort of the foundation for these cases that you've been working on?
Sure. The history of what's been known about benzene causing blood diseases and cancer is really very intriguing. The first cases of a condition called aplastic anemia, where the bone marrow gets poisoned to the extent can't make 2 or 3 lines of blood cells. White blood cells, platelets, red blood cells. Those studies coming out of Sweden in the 1890s. They're young women making rubber coats and other rubber products who were using benzene as a solvent and got this terrible condition and basically bled to death as a result. By the 1920s, there were reports of people developing leukemia following benzene exposure that were coming out. And by 1948, the American Petroleum Institute authored an internal document that was shared with its members that said that there were reasonably well-reported cases of leukemia following benzene exposure and that the only absolutely safe concentration of benzene was 0. And one of the first products they listed in that document from 1948 as a source of benzene exposure was actually gasoline. So you had internally oil companies in the 40s and 50s making it very clear that they were aware that exposure to benzene causes leukemia. And through the 60s and 70s, that knowledge grew. Unfortunately, public health agencies and occupational safety agencies in the United States were behind the ball. OSHA wasn't established by law until 70 or 71 and didn't actually start doing work until 72 or so. So they were behind the ball in trying to regulate benzene. They didn't have the information that the industry had. So certainly by the 40s, 50s, and 60s, oil companies were well aware of benzene causing leukemia.
And has the literature developed further over time, or I mean, sometimes it seems like what happens is, when these mega companies start to learn of the research, they will sometimes do or fund research of their own to undermine it, or once there's that clear link that starts to be made scientifically in the 60s and 70s, is there an effort by the oil and gas companies to counteract it in any way?
Oh, absolutely. You see internal documents from the American Petroleum Institute and oil companies in the 70s with a real kind of paranoia coming out that once OSHA starts accepting benzene as a cause of cancer, that's going to turn into the EPA recognizing benzene as a cause of cancer, and the public's primary source of exposure to benzene is from gasoline. So there are internal memos where the industry is saying, look, we're going to have to spend hundreds of millions of dollars in the US alone to either take benzene out of the gasoline or use systems to prevent the benzene from evaporating to where people can breathe it when they're filling their cars with gasoline, or where you have people living near gas stations or people living near terminals where gasoline is stored and loaded into trucks that delivers it to gasoline stations. So they start investing a lot of money in conducting epidemiology studies on gasoline exposed workers with the intention of using that to try and convince the EPA and OSHA that benzene or benzene in gasoline is not causing leukemia, that it takes a ton of exposure to cause leukemia if they're going to accept that, so that they don't have to invest this money to protect the public from the exposures. And what's more, they knew that the US was going to be kind of leading the world community in public health and protections. So they actually calculated the cost of what it would take to install these protective measures in Europe and Africa and Latin America and Asia. So they were very, very concerned with it. And you saw literature develop in order to rebut these claims from the government and efforts from the government to regulate benzene exposure.
Obviously, just from a simplistic standpoint, why is benzene even in gasoline? What purpose does it serve?
It's a great question. Gasoline has to have a certain octane rating in order to be explosive within the engine and power the engine. What you had until the late 70s was leaded gasoline, and the lead was in there to contribute to the octane rating. When the lead started to be taken out, we saw an increase in the benzene content of the gasoline. The reason there's benzene in the gasoline is there's benzene in the crude oil that the gasoline is refined from. So when the crude oil comes into the refinery, it gets boiled, goes up a column, and is separated out into different chemicals. Benzene is one of those chemicals, and some of the cuts that make gasoline have the benzene in it. Now, it's not necessary to have benzene in gasoline. It's not now really contributing to the octane rating of the gasoline. There's other safer chemicals that could be used in place of the benzene, but it takes money to remove the benzene from the gasoline. And so the question is the industry spending the money in order to take this known human carcinogen out and protect folks, or are they protecting their profit by not spending the money and keeping it in there?
Now, when you say they can take the benzene out, I assume you don't mean from the existing stockpile gasoline. You're talking about in the refining process of the oil, that in the making of gasoline, spending the money to put in place those steps that would take the benzene out before the gasoline's even manufactured and then put out for use by the public.
Correct.
And not to get too nerded out here, but why is that why would that be so expensive? Would they literally have to change the refining plants and so forth to create entirely new processes, and it just gets down to a dollars and cents decision?
I think it does get down to a dollars and cents decision. There were memos and forms that were circulated between some of the oil companies and the American Petroleum Institute in the late 1970s, once OSHA came out and officially declared benzene a known human carcinogen that they were going to regulate in the workplace. So the oil companies said, okay, well, how much is it going to cost us to get the benzene content below a certain concentration, say 0.01% in gasoline? And the figures were not that much money. So the technology was there in the 70s to significantly reduce the benzene content of the gasoline, but it took the investment to do so.
Is the primary risk posed to human beings, going back to what you're talking about a moment ago, the inhalation, of the benzene, or is it also potentially like if you get the benzene on your skin, which is probably for your typical person a lot less common, but I mean, are they both potentially dangerous, or, are you seeing in these cases predominantly, the inhaling process that is the sort of inciting exposure?
They're both very dangerous. And you make a good point in, well, how is the individual coming into contact with the what I would call the host solvent that has the benzene in it, the gasoline? There have been studies done on automotive mechanics, which was Mr. Gill's occupation, which showed that they actually received about 80% of their benzene exposure through skin absorption. And benzene's carcinogenic, causes cancer and blood disease, whether or not it comes through your skin, whether you inhale it, or in very rare circumstances, ingest it. It's recognized by the EPA and OSHA as a carcinogen through all routes of exposure. And the industry knows that as well.
So reading, what I could about Mr. Gill's case against Exxon, there seemed to be a primary defense, and it sounds like one that you encounter frequently, where Exxon and the other defendants that have to be sued in these cases say, hey, it's not the benzene, it's gasoline, or it's some other component. Can you, and I imagine this would take a long time to fully hash out, but can you generally explain how you explain to a jury or prove that no, it's not these other components, it's the benzene that is the primary cause of our client's cancer?
You're right. The industry, and ExxonMobil did this in the trials, they run from the benzene content in the gasoline. They try and treat gasoline as a completely different product in order to distract the jury away from benzene being a known cause of the cancer. So there's multiple lines of evidence that we can use to disprove that defense. First, there have been numerous epidemiology studies that have been performed on individuals exposed to benzene from gasoline. Some of them come from folks who drive the tanker trucks that deliver gasoline from terminals to gas stations. Others are the individuals that are actually working at those terminals. And then you have automotive mechanics and gas station attendants. There's a consistency among that literature of people having increased risks of leukemia and other blood cancers like non-Hodgkin's lymphoma as a result of the exposure to benzene in the gasoline. The other line is just kind of a more common sense approach. You have a known human carcinogen. You mix it with a bunch of other toxic chemicals, and now you want to tell me that it's all of a sudden safe? That doesn't make any sense. And in fact, there have been studies that have shown that when you have exposure to mice to both benzene and another chemical in gasoline called toluene at the same time, that makes benzene's ability to cause DNA damage actually stronger. It gets worse. So there's a effect between those two chemicals that can make the benzene more dangerous. Industry likes to rely on the fact that agencies like the International Agency for Research on Cancer and EPA have made statements like gasoline is a probable human carcinogen, but have not come out and said definitively that it is a known human carcinogen. And the issue with those studies is they're primarily done in the 1980s. So we have decades of epidemiology and toxicology studies that have developed since then. It's part of the reason the International Agency for Research on Cancer is going to be re-reviewing the literature on gasoline in the future. Another issue is that it's hard to find populations of workers that are only exposed to gasoline. So these scientists, particularly the IARC, which is very conservative, they want to rule out an exposure to another chemical that is responsible for causing leukemia before they make a definitive statement about gasoline. So it's hard to find a population of workers who is only exposed to gasoline before they can make that definitive saying. And then, are they going to say that it's the gasoline in total, or is it the benzene in the gasoline that's causing it? So that's another way to distract the jurors.
From a legal standpoint, when you bring these claims, what are the core legal claims that you are bringing against Exxon and the other defendants here, as far as the legal duty they had and what you contend they did wrong that then ultimately led to your client's cancer?
Primarily, we're talking about strict liability and negligence. On the strict liability side, it's failure to warn. In this case, Mobil, the predecessor to ExxonMobil, knew of benzene causing cancer since the 1950s and did not warn about really any health hazards, let alone cancer, on the gasoline pumps. They didn't use, in the 1970s, a document called a material safety data sheet that some other oil companies were using to provide warnings. On the strict liability consumer expectations test, which came about following tincture in Pennsylvania, this is a great product for the consumer expectations test. Gasoline is widely encountered by the population, and I bet if you polled 1,000 people, 999.9 of them are not going to know A, that there's benzene in gasoline, and B, that there's a cancer risk from being exposed to gasoline, just because you're kind of lulled into this sense of security from being around it all the time. So the consumer expectations test was something we proceeded to trial on, and is very, I think, strong theory for this type of case. On the negligence side, the duty is established by the fact that they have knowledge of the hazards of the product. They know people are using gasoline not only to pump it into their cars, but also using it as a solvent to clean parts. And it was foreseeable to them that they're being exposed to benzene and causing blood disease and cancer. There's another document from the American Petroleum Institute in 1967, which talked about mechanics using gasoline to clean parts and getting blood disease. So those are the two primary causes of action.
So I see a lot of times when, you actually get to trial, the different claims that you may have started with, some will drop away as you get down to, okay, now we've actually got to convince and persuade a jury to find in our favor. Did you try the case under all those theories, or did it get narrowed down to a particular couple claims? And ultimately, and I want to get into, how this case unfolded in the trial itself, but ultimately, under what theory did the jury find Exxon responsible?
Under those failure to warn, consumer expectation theories for strict liability, as well as negligence, is what our primary focus on, and what ExxonMobil was found liable under.
Okay. So let's talk about, it was Paul Gill, right? Is your client?
Correct.
Okay. So what type of cancer did Mr. Gill unfortunately develop?
He developed first acute myeloid leukemia.
And tell us about that. Yeah. What is that cancer? And I assume it falls into one of the categories of a type of blood cancer that is associated or linked to benzene.
Right. Acute myeloid leukemia was the first type of cancer that OSHA and the EPA and some of these other organizations recognized to have been caused by exposure to benzene. Acute meaning the more severe form of leukemia, and myeloid meaning it's in a line of the white blood cells. So the cancer can come about from DNA damage to stem cells that are there to produce our blood cells, as well as what are called epigenetic changes. So changes to the machinery that controls how our DNA comes apart and comes back together when cells replicate each other. And I say that was the first form of cancer he was diagnosed with because he ultimately went through a stem cell transplant as one of the treatments for that, and developed colon cancer, colorectal cancer, as a result of the stem cell transplant.
So the stem cell transplant itself then led to the colorectal cancer he developed later.
Right. The immune system plays a role in fighting cancer. Our immune system identifies malignant cells, cancerous cells, as a foreign body and kills them off. When one receives a stem cell transplant, you have to turn off or significantly turn down the immune system for a long period of time because the donor stem cells can recognize the body as a foreign substance and attack it. And that actually happened to Mr. Gill. He was still to this day experiences what's called graft versus host disease, that stem cells attacking the body. So by turning down or turning off the immune system, that reduced or eliminated his body's ability to fight off the colon cancer. So the colon cancer developed and actually metastasized to his liver. So he's continuing to go through surgical procedures for that.
So tell me a little bit about the story the jury heard about Mr. Gill. Like what was his lot in life? What had he done for a living? And what was it that you were so certain had brought him into substantial contact with benzene?
Mr. Gill is really a remarkable gentleman. Somebody I personally admire. He grew up in northeastern Pennsylvania in very, very modest circumstances. His father was a Korean War veteran, had obvious PTSD, which led to him consuming too much alcohol and leaving the family when Mr. Gill was young, I think around 7 years old. So his family lived in a former schoolhouse that was a single room. They ran a wire down the middle of the room, hung sheets to separate the parents from the kids. They had food insecurity, so at the end of the month, they would oftentimes have to walk on the other side of the hill to their aunt's house just to have something to eat at the end of the month until his mother, after putting a gun on layaway for about a year, he was able to go out and hunt deer to supplement the family's food. He started working on farms at a young age. He was a big, strong guy. He testified that he could take a 50-pound bale of hay and throw it 15 feet into the air from all the work he's done on farms and was still doing right up until the point of his diagnosis. So one of his first jobs was working at a mobile branded gasoline station up in northeastern Pennsylvania. He worked there from 74 to 79 as an automotive mechanic. Pumped some gas, but primarily what he was coming into contact with benzene from was using Mobil's gasoline to clean parts. Gasoline is a very, very well-functioning, phenomenal solvent. So did a great job of breaking down the grease and the oils and the parts that he needed to clean, and he was doing this day in and day out, and actually lived in an apartment above the mechanical shop right next to the gas pumps for a little over a year with his family.
So goes on, he's working. Was he still working at the time of his diagnosis?
It's one of the sad things about his circumstances. The year before he was diagnosed, he retired from working security for about 20 years at Owens Corning, Corning Glass Company up in New York. So here he and his wife had just reached the point where they're able to enjoy their lives after working for 40, 50 years, and this cancer hits him.
Gotcha. So, walk me through the workup of the case. You somehow, Mr. Gill finds his way to you and your firm. You start looking through his medical records. You see the type of cancer he has. You, I assume, interview him, learn about his history, and, without, divulging too much of your secret sauce, I mean, how do you go from there to making the decision that this really appears to be a case where this gentleman's unfortunate diagnosis was the result of, his years ago excessive exposure to benzene?
Sure. So our investigative process is identifying what was this gentleman exposed to in the first place, how long a period of time was he exposed to it, who's responsible for those products, and also considering is there something else in his personal or family history that would explain why he developed AML. There's some other known causes of AML, like high doses of radiation from an atomic bomb or radiation therapy for a cancer. Chemotherapy did not have any of those in his background. A little more controversial becomes whether there's an inherited mutation that can cause the AML. There's no family history of leukemia that would suggest that there was any type of mutation like that. Um, and so the workup is identifying what were the exposures, how much exposure did he have, and are there other explanations for why he developed the AML. And we were able to determine that he did have a very significant history of exposure to benzene, and didn't have anything else that would explain the cause of his AML.
So he's working, for a significant period of time at a mobile station, which is obviously owned or subsidiary of Exxon, the ultimate defendant in the case, right?
So Mobil and Exxon were separate corporations until about 1999 when they merged. And this gas station was operated by a separate company, the gentleman he worked for, but they had a transactional relationship with Mobil where the documentation we obtained indicated that Mobil actually owned or controlled the underground storage tanks, the gasoline pumps that were being used at the facility. So there was another level of control of what was happening at the gas station, aside from just manufacturing and selling the gasoline that was being used there.
Reading I'm not sure if it was a Reuters or a Forbes article about your verdict, it said that there were numerous other defendants in the case, at least at one point or another, but ultimately Exxon was found 100% responsible. To the extent you can talk about it, were all those other defendants in trial, or had they either, resolved out or been let out by the time the trial came around?
It was only ExxonMobil left at the time of trial, so there were resolutions before then. However, most, if not all, of those companies did go onto the verdict sheet. And because these defendants are often so fixated with trying to show that something other than benzene caused the plaintiff's cancer, they didn't really work up a liability case against the other defendants. So that allowed us to really focus on ExxonMobil, and not only during the course of trial, but in closing. And as I walked the jury through the verdict sheet, make a strong argument about, look, we spent all this time, we took your time to put on the evidence about what ExxonMobil knew, what they did and didn't do, why that caused this gentleman's cancer. They had the burden to do the same as to the other defendants, and they didn't put that effort on. They didn't put the evidence on. That was a strategic decision that they made. They thought that was the best strategy, I assume, but it didn't work.
Am I right in guessing that in a case like Mr. Gill's, when there is, this long history of literature, supporting your position, probably numerous other similar lawsuits that have been litigated or tried in the past, is there a significant aspect of the case that, for lack of a better term, is kind of in the can already, as far as the core evidence in the case, or for, say, Mr. Gill's case, are you essentially starting from scratch as far as working it up, who you're deposing, in the general discovery process?
So there was a mix here. We've been handling cases against ExxonMobil for quite some time, so we've been able to take their depositions in past cases, gather documents in past cases. The hybrid comes in that getting the Mobil gasoline from the source to the gas station where Mr. Gill worked, finding out what was or was not done about providing warnings to that particular gas station. That was all new information that we had to gather in this case. So there were several parts to that. One being was that there was a distributor that actually took Mobil's gasoline from the terminal to the gas station where Mr. Gill worked, called Root Oil. And so gathering the documents and the testimony from Mobil and Root Oil about the nature of the relationship between Mobil, Root Oil, and Cole's Garage, where Mr. Gill worked, was all something that we had to develop in this case in particular. And it became part of the case part of the case at trial because ExxonMobil was attempting to shift blame to Root based on some language in the contracts between the two companies. Obviously, it didn't work. So there was a component of this case that was very new. There was a component of this case that we had already developed.
In my experience, it seems that painting with very broad strokes here, every sort of category of cases there's good things about it, like overall, and then there are difficulties with those types of cases. I've heard tobacco litigation is extremely difficult just because of the mechanism of the defense machine. Medical malpractice, which I do a lot of, one of the biggest difficulties is that people generally like doctors, and they're fond of them, and they have a hard time holding somebody that was trying to, at the end of the day, try to provide care responsible. But there, on the other hand, there are very good, in the tobacco litigations, you've got nobody generally is a big fan of tobacco companies, and in medical malpractice, there are the medical records, which can provide you a nice foundation basis for proving your case. In these exposure cases, and we can keep it specific to a benzene exposure. As you look back, you've been doing this for a long time. What are the parts of the cases that are appealing from being the plaintiff lawyer representing somebody like Mr. Gill, and what are the biggest obstacles that you face in these cases as far as the path to victory?
So the appealing part, particularly with an oil company, is just the overwhelming amount of evidence of what they knew about benzene causing cancer and what they failed to do to protect the public from that. It's very, very persuasive. The challenges come from you have somebody who's working and exposed in the 1970s. What documentation, what witnesses are there left to corroborate their story? What's their medical condition when the case comes into you and they're going through really high doses of chemotherapy or a stem cell transplant? And has that affected their memory and their ability to give testimony with the details that become convincing? And then there is kind of an intuitive hurdle for a layperson of why did exposures in the 1970s cause cancer in 2019? And then distilling the science, whether it's the epidemiology or, in my opinion, very importantly, the mechanisms of how benzene actually causes this DNA damage and epigenetic changes at the stem cell level, to explain why the cancer developed decades later, and distilling that into terms that the jury can easily digest and understand and discuss in the jury room when they're rendering their verdict.
So, everything that you're talking about, I mean, there's a lot of science, a lot of documents that have to be marshaled for purposes of, how do you present your best evidence to the jury? And it strikes me this is not the type of case you just go in there and try as a solo. I imagine on both sides there are teams of attorneys, and can you explain for me, what your team consisted of, and sort of how you approached putting this case onto a jury in a way that they were going to get it and see things from your perspective?
So I worked with two great lawyers from our co-counsel's firm, Waters and Krause, Patrick Weigel and Rajiv Mittal. We actually had Rajiv and I worked on another case in Oakland just until last week. We, in terms of the medicine and science, wanted to put on a case for the jury that explained not only what was known by the time Mr. Gill was exposed, but used the kind of cellular level discussion of how benzene causes cancer through our hematologist oncologist expert, and a discussion of what the epidemiology has shown from our occupational medicine physician slash epidemiologist slash toxicologist slash industrial hygienist that we had testify, and showed to the jury what types of benzene exposures are caused by gasoline, what types of benzene exposed populations have been shown to be at increased risk of leukemia due to the benzene exposure, as well as what's happening at the stem cell level and the cellular level when benzene causes this cancer, and how those stem cells that we're born with and are intended to be with us for the rest of our lives, how that damage accumulates over time and eventually manifests into the clinical disease of leukemia.
So simplifying it, would you say, as far as chunking out your order of proof in your case, Did you start with causation, talking about the process of how benzene causes cancers like this, or did you start with, the historical knowledge, more, liability fault perspective, to before I assume, and then you build into the damages component with Mr. Gill and whomever else to talk about the impact that this has had on him?
Right. So we actually had Mr. Gill as one of our first witnesses to describe what his exposures were and what his experience was. And then we followed with our expert, Robert Lombach, who is an expert not only in industrial hygiene, which is the science of looking at what the exposures are, but also occupational medicine and toxicology and epidemiology. So he laid a foundation of what was known over the years about benzene causing blood cancer and blood diseases, what types of benzene exposures are experienced by individuals like Mr. Gill and Mr. Gill specifically, based on his testimony, and what the epidemiology has shown in terms of levels and concentrations of benzene in populations that develop leukemia from exposure to benzene. Then we followed that up with our oncologist hematologist, who was able to provide kind of a more in-depth cellular level description of what's happening or the mechanisms of benzene causing the cancer, as well as the therapies that Mr. Gill went through and how the stem cell transplant led to his colon cancer. We also had two ExxonMobil corporate representatives that testified in the case. They tried to limit their testimony to just the gasoline refining process and tried to minimize the amount of benzene in the gasoline. Didn't really bring in any scientists on the toxicology or epidemiology or industrial hygiene side. So we were able to get some admissions out of them about the medicine and science. We had many more from depositions that we unfortunately weren't able to get into evidence in this particular case because of rulings on motions in limine. And then we did follow up with Mrs. Gill's testimony about how the cancer has impacted their marriage, as well as Mr. Gill individually, because he's a very stoic, very matter-of-fact gentleman. The only time he really showed emotion when he testified was he told a story about he was actually a volunteer EMT and a volunteer firefighter, went on to teach EMT classes, and one day he was driving down the road and saw a woman jumping up and down in an emergency because her baby was essentially choking to death. He was able to save the baby's life, and about 18 years later, that individual and his brother came to his EMT classes, and he taught them to be EMTs, and he really broke down in that part of the testimony, as well as his testimony about his fears for what's going to happen to his family should he pass away from this disease. And I thought that was profound because this showed that this is a gentleman who thinks of others first, cares about his community, cares about his family. And there was a real contrast to ExxonMobil and them basically doing the opposite.
How long was the trial total?
It was about 8 days.
Okay.
I think deliberations went into the 9th day.
Gotcha.
So not short, not long. Good length for a trial.
And you tried this in Philadelphia?
Correct.
Walk us through the jury selection process. I mean, how did it play out? I would imagine there were certain types of jurors or, belief frameworks that you were looking either to have or not have on the jury. But, what was the approach in general, and what was your sense of how Exxon approached jury selection?
The jury selection process was a little different than what we typically do in Philadelphia for two reasons, in that our judge actually participated in the voir dire. That's not too common in Philadelphia. It's probably more common just to have the tip staff conduct the voir dire. And it was on the record. It was the first time I've had jury selection in Philadelphia where there was a court reporter present. The individual voir dire was not super extensive. I think you had mostly questioning from ExxonMobil of potential jurors about what they knew about the company, looking for folks who had a bias based on, I read about Exxon Valdez, or I have really strong opinions about environmental damage or things of that nature. And we just wanted to flesh out with folks, what life experiences did they have that might inform what they knew about how mechanics did their jobs, what exposures they had, what background knowledge in medicine and science did they have that they might bring into their decision-making process. We ended up with a very diverse jury, not only in terms of their background, but also their professional experience, socioeconomic status, which was, I think, really ideal in that you had folks with very different perspectives viewing the evidence and making a decision in the case.
Who of your trial team who handled opening statement?
So I handled the opening statement.
Can you walk me through I don't know if you have a sort of standard process or you come up with it uniquely for each case, but how did you approach, sort of the sectioning and conveying this information to the jury? Did you use a rule? Or rules, or did you more, just like you've described so far, talk about the history, what they've known and everything, and then walk them through the legal basis for your claims?
So I do like to put liability forward. So we start with a rule and we end with a rule in closing as well. And we
Same rule?
Same rule.
Based off of, just kind of Friedman's rules of the road concepts, like things they have to agree to, you can clearly show it's been violated, that sort of thing.
Absolutely. Simple rule that's really hard, if not impossible, to deny without looking completely unreasonable.
What was your rule, or approximately?
It was essentially that companies should not needlessly endanger users of their products.
Got it. Did you work that through any portion of the testimony, like say with the corporate reps or representatives of the defendant, or was that more just kind of a framing point for opening and closing?
It was both. It was a framing point, but something we got ExxonMobil's corporate representative to agree with. And then I think once you do that, you don't have to do a whole lot to say, well, okay, you've agreed with this rule. Would you agree that you violated this rule by doing this or that? Because they're going to deny it. So you can lay the evidence around the rule and allow the jury to reach that conclusion. I think you really want to empower the jury to see the rule, see the evidence, and make their own decision about whether that company complied with it or not. So that's how we presented it, and the opening really started with the liability case and the rule. Spent time talking about what was known, but also spent a lot of time talking about the science of how benzene exposure causes cancer, because I knew that ExxonMobil was going to front load their defense on gasoline's not benzene. Gasoline doesn't cause cancer. Gasoline doesn't cause cancer. Gasoline doesn't cause cancer. So I wanted to educate the jury on what evidence there was that supported our side of the case, and try and break it down into the terms that they were going to understand and have it stick with them.
Were you allowed to use demonstratives, exhibits, evidence in opening, and if so, what did you choose to focus the jury's attention on?
So we were able to use PowerPoints in opening, and we tried to focus our attention on some of the key principles in terms of the causation, familiarize them with the workplace, and start to get visuals for them to understand the exposures, and some of the basic medical and scientific principles. It wasn't too heavy in terms of documents that we thought were going to come into evidence or not, because there was uncertainty about what was or wasn't going to come into evidence. So that was our approach on the openings.
Did you go out of your way to, point out, that here's what I'm pretty sure Exxon's going to say, and why it's irrelevant or inaccurate in how you were going to show it? Or did you simply address and inoculate their defenses by showing the jury the history and the evidence that you had that proved your case that it was the benzene and not gasoline?
I think it's important to take their defenses head on, point out what they are and why the evidence is going to show that they're not to be believed, why the evidence doesn't support them. So that's oftentimes my approach in the opening statement. I think that's what we're able to do in our opening statement in this case.
And I would imagine sometimes you're probably a little concerned about overstating, the damages, or getting, too ahead of yourself maybe. So when it came to talking about Mr. Gill's cancer and the impact of it, how did you, kind of walk that line between adequately commenting on it without, maybe overdoing it, so to speak?
Sure. So the good part about this case and these cases with folks who go through leukemia is there is just a very well documented course of medical care with painful bone marrow biopsy procedures where they actually use large needles to drill into the pelvis bone and extract the bone marrow, not once just for the diagnosis, but after each round of chemotherapy, after the stem cell transplant. Well documented course of chemotherapy and side effects that are in the medical records. So it was easy to expand the pain and suffering over a long period of time because it had been about 5 years from his diagnosis to the trial, and very factually walk through the medical procedures and treatments he had been through and how they affected him physically. So it wasn't necessary to overstate anything, just laying everything out in a very matter-of-fact manner, which was consistent with how Mr. Gill testified in a very matter-of-fact manner. And with those details there, I don't think you need to do a whole lot more.
In your, your case in chief, you talked about Mr. Gill testified, his wife testified from a damages component. Did you have any other damages witnesses, be it treating doctors or anybody else?
Our our oncologist hematology expert was able to testify about these procedures and how they impact the body. But we didn't use any treating physicians or any family members beyond Mrs. Gill herself.
So we'll let the cat out of the bag. What was the ultimate verdict in this case, Andrew?
$725,500,000.
Obviously, quite a verdict. As you look back on, how the trial unfolded, were there, certain moments that you felt, drove this, for lack of a better term, magic moments in the case, or, gifts that defense handed to you? Or was it predominantly just kind of the character, nature, background of your client, and a jury that was not okay with the evidence that they heard about what Exxon knew and chose not to do?
So it was a combination. Paul Gill and Diane Gill are such wonderful individuals that they were able to, I think, relate to the jury, or the jury was able to relate to them. Had a very compelling story about his life history and when he went through with the leukemia. But then on the other side, and he's been through just hell and is continuing to go through it. It was also remarkable that despite what he's going through, he still tries to get out on the farm, still tries to do work, because he thinks in his mind that that's going to help him stay healthy. So he's a fighter, and I think people like that. There's not a woe is me attitude, not a drop of that in his blood. On the other hand, you had ExxonMobil take such a indignant, arrogant position about their gasoline being safe and benzene in their gasoline not causing cancer, and this being such an important product for them, that I think that the jury definitely was able to see through that, and didn't appreciate this company with this clear knowledge of this chemical causing cancer, not only not doing anything to protect people about it, from it at the time in the 1970s, but now trying to sell a story that just doesn't float. In their opening statement, they made, I think, was a pretty significant mistake, and they said to the jury, look, Mr. DuPont told you that they're proceeding on a consumer expectations theory and consumers don't expect gasoline to cause cancer. We agree, consumers don't expect gasoline to cause cancer. And when you're putting a failure to warn claim and a consumer expectations claim on, that's a pretty powerful concession that I was able to make a lot of use out of on my closing.
And was there a punitive damage component to this, or was it all compensatory damages?
It was all compensatory. Punitive damages was dismissed on non-suit. We did have a fraud count, and we're proceeding for punitive damages. The judge, I think, also dismissed a recklessness claim on non-suit. So this was all compensatory damages.
So what was the breakdown? Did you put past and future medicals in, or was it all non-economics?
It's all non-economics. There were four line items of compensatory damages for Mr. Gill, plus the loss of consortium. The loss of consortium was $500,000. The four line items, I want to say, were $425 million for his physical pain and suffering, $181,250,000 for his embarrassment and humiliation. There's a line item for disfigurement and loss of life's pleasures. A compelling part of his loss of life's pleasures and his mental pain and suffering was, here you had a man who really lost out on having a strong father in his upbringing and struggled as a result. And then he had this beautiful relationship with his kids and grandkids because of his experiences hunting growing up. He raised his own kids to hunt. They went into the Marine Corps, and the comments from the drill sergeants were, they couldn't miss the bullseye on the target. And it was, well, you must have grown up somewhere where if you couldn't shoot, you couldn't eat. And I thought that was a beautiful story about what he passed on to his kids and how they spent time together as a family. And then what this cancer took away from him in terms of his ability to not only be with his family, but provide for his family, loss of this sense of security. That was so important to him based on his upbringing.
Yeah, that's. I mean, it certainly helps when your client has such a compelling background, is such a quality human being on top of the hell they've been put through, and a corporate defendant that has been so recalcitrant to change. As a trial lawyer, Andrew, you do the opening and closing in obviously this very high stakes case. As you look back on your career, what would you say are the biggest influences, be it books or seminars or attorneys out there that teach, or is it just your own personal or mentors that has influenced the way that that you approach trial these days?
That's a great question. I've been lucky to observe and learn from some great trial lawyers, not only at our firm, but in other firms. One of which a good friend, Joe Satterley, out in California, was able to spend some time with recently, and learn from them. I think the diligence that you have to put in terms of putting on a persuasive case, but how can you be very assertive with a defendant and witnesses without coming off as somebody who's a jerk. How do you be nice and relatable while at the same time being firm and getting your point across? How do you tell a well-organized story that persuasively convinces a jury about the liability case? And you have to also learn how to handle judges when they're not ruling in your favor, and perhaps even admonishing you in front of the jury. How do you keep your cool? How do you keep focused on what you need to do and continue to put on your case? So I was trained under a former U.S. attorney who was a very aggressive and strong trial attorney, and I think that taught you how to be very firm and how to make sure you're following up and get the answers that you need when they're evasive the first, second, third time. Other attorneys who just have a very, very relatable and nice demeanor in front of the jury while effectively getting the job done. Those types of influences all kind of influence my practice. And then you have to know, what are you comfortable with? How are you comfortable with addressing the jury? Are you somebody who feels like they have to stand behind a podium when giving a closing argument? Can you walk up close to the jury when it's time to make some important points? And so you kind of develop your style over time. And we're a craft, we're a trade, we're a culture, more so than I think than other professions. in that these skills get passed down from generation to generation, and it's really the only way to develop them is from observing and doing. It's not something you can learn in a classroom. It's not something you can learn with books, in my experience.
Very well said. So, Andrew, I really appreciate you, sharing this story. Amazing verdict. It sounds like for an amazing family, and you guys obviously did an amazing job trying this case. If attorneys want to pick your brain or refer a case to you, what's the best way for people to get a hold of you?
Absolutely. My email is DuPont, ADUPONT @loxlaw.com. And my cell phone is 267-334-5098. We do have a kind of a nationwide practice, so I'm traveling a lot. Just had a trial in Oakland, California. So those are the best ways to get in touch with me. And there's a lot of people out there that need help. A lot of people have been wronged. We have no idea that they've been exposed to benzene and then decades later develop leukemia. There's no possible way for us to represent any individual. So I think we also have a responsibility to educate other lawyers about how they can best represent individuals in this position. And I've benefited from other lawyers taking time to teach me when they weren't earning anything off of it. And I'm very, very happy to talk to other lawyers and teach them about this litigation so they can do the best job that they can for their clients. Because ultimately, the last thing I told the jury in my rebuttal was, if you take away anything from this case, I want you to understand the hazards of benzene and gasoline, and I want you to tell other people, because it's a major problem that people don't know this, and they're not being protected because they don't know that they have to protect themselves. So educating the public, I think, is a very, very important part of our job.
On that point, that's a wonderful way, to end your closing and to almost end our interview. But is there a resource that whether it's attorneys or people, non-attorneys who have a concern about the type of cancer they or a loved one developed, where would you say are the best resources to learn about what you were telling that jury about understanding the actual risks of exposure to gasoline and benzene?
Good question. On the lawyer side, we have a litigation group through the AAJ for attorneys that handle benzene exposure cases. So any attorneys looking to get into litigation should look into joining the litigation group. On the public health side, there are some resources out there through the Leukemia Lymphoma Society puts together pamphlets that you can find in doctors' offices that provide limited information on benzene and what it can be found in and how the exposures can happen. But it's difficult to find a very comprehensive source for the public to learn about the hazards. The EPA website has some information on it. ATSDR, Agency for Toxic Substances and Disease Research, has information on it. But they tend to be pretty technical. They will point out gasoline as a source of benzene exposure. They will caution against people letting their families play near gasoline stations, live near gasoline stations. But you really have to do some digging into some large documents to get at that information. So I would like to see a much better effort on behalf of our government to educate the public about these issues, because it's certainly not coming from the industry.
All right, man. Well, thank you again for sharing your story. It was really entertaining. I got a lot out of it, and congratulations again. And thanks for joining me on the Just Verdicts podcast. Maybe one day we'll have you back on with another monster verdict in the future. So thanks again, Andrew.
Thank you, Brendan. And I want to extend those congratulations to the paralegals and the trial tech staff and my colleagues, Patrick Leibel and Rajiv Mittal. Everybody really did a heavy lift on this trial and did a great job working for Mr. and Mrs. Gill. So I appreciate everybody's effort.
Takes a village.
Absolutely.
If you enjoy the show, please subscribe to the Just Verdicts podcast on your favorite platform and consider leaving a review. And if you're interested in co-counseling, local counseling, or referring a catastrophic injury case, we'd love to work with you. Call us at 412-281-4100 or visit our attorney referral page at pamedmal.com/refer. Thanks for listening.